Welcome to Notable Approvals. I am attorney Amanda Shaffer. I have another exciting case to talk about today. Before I get to the case, as always, don't forget to like us and follow us Facebook, YouTube, Instagram, wherever you are watching. If you find this video to be helpful or know someone who may find it helpful, go ahead and click that share button so that you can share the hopefully useful information as well. So, today's case is about a client who is a native and citizen of Nigeria. And she first came to the US in May of 2018, and she filed for asylum just under a year later, so within the 1 year filing deadline. Her asylum was based on her membership in a particular social group. Specifically, she was a woman who married into a family that has a tradition of performing FGM, or female genital mutilation, or female circumcision, which is a practice that is done, unfortunately, in a lot of places still. But essentially what happened was that she got married in 2016. She's Christian, and she married someone who's Muslim. And there's all sorts of reasons that FGM is performed. Sometimes it's religious, sometimes it's traditional, which means that it has to do with your family, your culture. It doesn't necessarily connect it to religion, because we do have clients who are Christian that from Nigeria that face the same issues. So she married into this family, and a couple of weeks after marrying in, she finds out, well, now that you're married, we have to perform FGM on you. And she was like, no, I'm not doing that. And they started threatening her, and more and more and more. Eventually, she realized if she didn't do the practice, which is really harmful, it's not done in the hospital, it's done usually by like the elder women of the family, and it's very painful. And then often women have a lot of problems after the fact, whether it's with their reproductive system as a result of the FGM. And when you try to object, you're often ostracized or even beaten. So many horrible things, but this unfortunately is the type of case that we handle a lot. So we're very familiar with it. So what she ended up doing was she ran away to a different part of the country, but there wasn't anywhere really for her to go, because even though in 2015 Nigeria passed like a national law that outlawed FGM. Number one, Nigeria is split into states, and they're kind of individual, but it's not like the United States. It's more like, if you know the Articles of Confederation, where they're like they kind of have their own laws, but they're also under the national law. So basically, the local authorities and any authorities didn't do anything, even if you reported it. This is still seen today in most places, that in Nigeria and in other countries where this practice is still performed, as a family issue. So the police will not get involved. We have a question from Juan, who says, did this fall into the woman who cannot escape their relation's social group membership for asylum purposes? That is a great question, Juan. And yes, in a way it did. That wasn't exactly how we described it, but that was part of it. The FGM component, the fact that serious harm can come on someone, which is in many circuits in this country, but in the Second Circuit, where New York is, they have ruled that FGM is a form of persecution. So the fact that she's being threatened with persecution, and then we connect it to either the ethnicity or the religion, is what it was. And then you also throw in the fact that she can't leave her relationship. And that's why we didn't have to prove really the relocation element here, because although she did go to Lagos, which is the capital, which was far, I don't remember how far it was from her husband's family, but I've done a lot of these cases, and the fact is that her family's going to track her down, and they're going to drag her back and they're going to force her to undergo it. She's not going to be able to get divorced. She's not going to be able to live independently. So to your question, Juan, yeah, it is part of it, but the mere fact that you can't leave your relationship is not necessarily grounds for asylum. Usually has to be connected to something else, such as a religion, such as ethnicity, and you still have to show that because it's the government has to be unable or unwilling to protect you. So there could be a law that says you can't beat your wife, for example, or your spouse. But if you go to the police and the police won't help you because they say it's a family matter, then we're falling more into the asylum claim. So thank you, Juan. That was a very good question and a good point to make. So where were we? So basically, the threats were coming from her family. It was her mother-in-law, the husband's family, and she was able to get a visa and come to the U.S. And within a year of coming here, she applied for asylum. Now, I remember this case because for one reason in particular, that at the time in 2018, that was when they changed how they were processing asylum interviews. So we had clients waiting since, I don't know, 2014 for interviews. Maybe that far back, at least 2016 for interviews, for just your asylum interview. And they decided to try to cut down on asylum fraud, that they were going to interview you within 30 days of filing your asylum application. Now, if you're wondering how that has turned out since then, I don't even know if Biden administration removed that rule completely, but COVID made it really difficult. They were already having trouble doing this, but made it really difficult. And we have clients who filed in 2019, 2020, still waiting for interviews. So she was lucky in that she was able to get interviewed very quickly, because she may still be waiting just for the asylum interview at this point, like some of our other clients are. So she had her interview, and let me mention the evidence we submitted, because I also remember this case because it was a very straightforward case in the Second Circuit. We're in this jurisdiction, and she had not undergone FGM, and we've had clients who've had it, and then you have to link it more to other types of harm related to the FGM, which gets more complicated. So it's easier when you haven't had it done and someone's threatening to do it to you. So you go get a medical exam, which she did. So we submitted proof that she had it done. The threats were all verbal, so she had nothing written. She wrote a statement, compared to some of the statements we write, it was not as long and detailed, which again, it's case specific. We just didn't need it in this case, because it was all about whether they were going to believe her or not. We had the country condition information about Nigeria and about how FGM is handled in the country. And we had her statement. We had, her medical exam showing that she didn't. And basically it all came down to her interview and whether or not the asylum officer believed her. And the asylum officer believed her, so she was granted at the interview. So I think it was within 2 months she had an answer, and she had asylum and became an asylee. And compared to what a lot of people who may be watching this even are sitting there saying, that sounds so easy, I'm waiting forever, or I waited forever, you are correct. A lot of people majority of people wait much longer. Like I said, she happened to get her application in there right when they changed that rule, and was able to get her interview. And she's a very credible person, and there was no reason not to believe her, and she was granted. Her case could have just as easily been deferred to the immigration judge, because they may have said that you didn't have enough detail. The officer might not have believed her, even if she was telling the truth. I have cases all the time that end up in court where it could be one little thing. The asylum office does not grant that many cases because they don't deny them. They can't deny them. Instead they have to refer them to court, where you get to go before the immigration judge and do your case again. So if there's any doubt about anything, they don't grant them. They just refer them to court. So we were very excited for this client when it happened. And when you're granted asylum, a year later, you are then eligible to apply for your green card. It's actually 9 months later. So technically your eligibility starts a year after your grant, but you can apply up to 3 months before that year. So 9 months later is like when you can first submit your application for your green card. And not around a year later, she did submit her green card application. And Asylee-based green cards are pretty simple compared to other types of green cards, because if you don't have a birth certificate, not a problem. If you don't have an entry with inspection or parole, not a problem. If you don't need an affidavit of support, so you don't need to show that, you don't need to find somebody to sponsor you and show they make a certain amount of money. So it's just less documentation, which is nice. You do have to submit. We submitted her passport, biographic information page, electronic I-94. She did enter with the V2 visa, so we showed that proof as well. Proof for her asylum was granted, of course, and that's really all we needed. And it was a little frustrating that we were waiting for about 2 years for that to get granted. We then got a request for evidence this year that said she needed to do her medical exam, which we knew because they had changed the rule by then that you didn't have to submit your medical exam with your application because it might expire. And in fact, she would have had to redo it anyway, because since she filed her application, the COVID vaccine became mandatory, so she would have had to get a new medical anyway. And they also then asked for her birth certificate. And I remember getting this request for evidence a few months ago, and I always get annoyed when immigration asks for things that like they clearly don't need to be asking for. So because even if she had a birth certificate, great, we can submit it. But it's just not a requirement for asylees or refugees for that matter. And the medical exam, we were happy when we saw that, because we were like, okay, this means that they're almost 0% chance they're calling her in for an interview. Otherwise, they'd send her the interview notice instead of the request for evidence, and then they'd say, bring the medical exam to your interview. So we sent the medical exam, and we wrote a little letter saying, show again, submitting the proof that her asylum was granted, and then just citing the law, like, asylees are not required to submit birth certificates, period. And a couple months later, she was finally granted and is now a permanent resident, and we are very excited for her. And she also did file, I didn't mention this, about a year after she was granted asylum, or less than a year after, she filed what's called a follow to join application for her daughter, who's still in Nigeria, so her daughter can come over. That is actually still pending and hopefully will be decided soon. But when you're granted asylum, you only have, I forget off the top of my head if it's a year or 2 years after your grant to do the follow to join. And that means you don't have to go through the whole family relative petition process, which you can do also. But you can't do that until you have at least your green card. So you're able to get the process started. So that should be approved soon. There's no reason it won't be. And then also, because she's an asylee, her time period for naturalization, for how long she needs to be a permanent resident, has technically already started. So you get 1 year. You get 1 year as your asylee that goes towards that naturalization requirement. So she really only needs to wait 4 years now from the day her green card was issued before she's eligible for naturalization. So she can actually apply in 3 years and 9 months is the first day she can submit her application for naturalization. I know she is already put the date on her calendar and is ready to go. And we, of course, did as well to remind her. So we're very excited for her. It's almost for us ironic for a client who, in her situation, is like, oh, it felt like it took forever. And we're like, it did take a long time. It's been 4 years start to finish from entering the green card. But in the asylum world, this is quick. Very quick, actually, surprisingly quick. So that was I just got to give her a hug today, so that's why I wanted to talk about the case today because I always like to do it when I'm excited and have a couple of minutes to do this. But basically, this is a great example of a case where you don't always, it's not about submitting a mountain of evidence to get your asylum granted. It's about being truthful and being credible. And she went into that asylum office and she just told them her story, and she was honest and straightforward. And that's why she got granted, even though, I mean, I took a look at the application today and I was like, oh, that's all we submitted. I was like, because, you know, for certain cases, you end up having to submit more. Got a second question from Juan. Let's see what we've got here. How, in your opinion, does the recent SCOTUS opinion virtually allowing indefinite detention of certain applicants impacting asylum cases in general? Thanks in advance. Well, Juan, in advance, you're welcome. So what he is talking about here is that the Supreme Court recently issued a decision. No, it wasn't the Supreme Court. I think you're talking about the Texas case. It was a circuit court. I don't think it made it to the Supreme Court yet. But there was a case that came out a few weeks ago that said that, oh, well, there is a Supreme Court case about the indefinite detention, which is separate, but I think you're referring, and tell me if I'm wrong, I think you're referring to the more recent one. So there's a memo that came out a year ago, a little less than a year ago, that said that immigration is going to shift their focus on certain priority categories, and they're not going to detain people that don't fit into these categories, and they're very, very narrow categories: national security threats, public safety threats, and terrorist threats. So there are provisions in the immigration law that say if you fall into this category, you're subject to mandatory detention, meaning they can't release you. They don't have a choice. They don't have discretion. They have to put you in detention. Problem is, there's not enough room for everybody. And some of the people that fall into this category include, this case was decided 3 weeks ago. Okay, so this is the case I'm talking about. Okay, we're on the same page, Juan. So basically, this case said that if Congress, who passes the law, says that somebody is subject to mandatory detention, then the Department of Homeland Security, who makes these decisions when it comes to detention for immigrants, they can't ignore that and say, well, we don't want to detain them. And one of the groups that falls into mandatory detention are people who enter the country illegally. And sometimes some people, if they pass a credible fear interview, can get released. I think even that they're not supposed to, but that's been going on. The catch and release thing has been going on for a while because we couldn't hold people. But we're talking about also people with orders of removal who DHS has not actually removed from the country. And this creates an issue too, because a lot of times people get released from detention because they're unable to deport them. So you're generally, unless you're a criminal, if you have a deportation order, ICE doesn't come knocking until they actually have a travel document in hand to deport you back to your country. So you're not supposed to stay in detention that long. This is saying you're staying in detention. And this says that Department of Homeland Security can't just cite, we don't have enough resources, because they don't make the laws. They are just there to enforce the laws. And that's what Congress is for. They made the law. They said mandatory detention. So how I think it's going to impact asylum cases, if for the people who would have been released, who are now detained indefinitely, it's going to be very difficult for them to find a lawyer. It's going to be difficult for them to get evidence for their case. It's going to be difficult for them to win their case. And they're also more likely to be held in courts in the South, because that's where they, close to where they entered the US, and those courts have much lower approval rates, and they're kind of churning and burning down there So due process rights are more likely to get trampled upon. And it's not a great situation. I think the ultimate goal of that opinion is to deter people, which has been something the government, this administration, is doing less of. But the previous administration, they spent a long time trying to deter people from coming and filing for asylum. So I think it goes more to, are people going to even try if they think they're not going to be able to get into the U.S. and get released from custody? It's going to cause overcrowding. It's going to cause a switch from the non-detained docket to the detained docket. So they'll probably have to take judges off of the non-detained docket, which is already really backed up, especially in a place like New York, where our courts were closed for a year and a half, but they're going to be sending judges down to the border in all likelihood. So I think it can impact it in a lot of different ways, unfortunately. But I think, whether I've read the opinion, I didn't read it with a fine-tooth comb, but I will say that one thing all lawyers will agree on is that if Congress says something in clear English that, this is mandatory has basic meaning, it's mandatory. Now, what do you do when you can't enforce that provision because you don't have the resources is another question. And Congress should act to do something. And if they don't, now we're in a catch-22. But that's where we are with that situation. So hopefully we'll, I know Biden administration said they're going to appeal the decision. It's not a friendly circuit where the Texas court is. I think I want to say the Sixth Circuit, but I could be wrong on that. And then, the Supreme Court is the last stop, and the Supreme Court is not a friendly Supreme Court for this matter as well. But I will say, in terms of what the law says, the law is clear that they have to detain people, that it's not their decision. It's a must. It's kind of like if somebody is convicted of a crime, and I'm not equating immigrants to crime. I'm just saying in the sense of prosecutorial discretion, if someone's convicted of a crime and there's a mandatory minimum of, let's say, a year for the crime, the judge can't, or the prosecutor can say, well, we'll do less than a year is fine. No, they're going to be in jail for a year, or actually, if it's a year or more, it's prison. They're going to be in prison for at least a year. So it's like a mandatory minimum where the prosecutor, the judge, they can't just put that aside because they don't have room or they don't want to detain the person or don't think that the person is a danger or flight risk. They have to do what Congress tells them. So I hope that answered your question, Juan. Thank you for asking both of those. Those are great questions. And that's really all I have today for notable approvals. Congratulations again to our client who now has her green card. I know she is excited. She was beaming when she came in today. One of my favorite things is to be able to share that moment with clients when they have something approved that they've been waiting for what seems like a lifetime. And it feels like a lifetime to me for a lot of these cases as well because of how long things take sometimes. So all of you out there, if you're waiting, be patient. It takes time, but eventually, hopefully things will work out. So don't forget, again, like us, follow us on Facebook, YouTube, Instagram, wherever you're watching, so you don't miss any more of our lives. If you find this video to be helpful or know someone who may find it helpful, hit that share button. And I forgot to mention this when I started, but if you need a lawyer or you have any questions, our contact information has been scrolling across the bottom of your screen on YouTube and on Facebook, on Instagram. If you go to our bio page, all of our contact information is there. We're here for you, more than happy to help. That is all today for notable approvals. We'll be back next time with another great case to talk about. Hope to see you then. Thanks for watching.